Hello everyone, and welcome to WooStream, where we're bringing Willamette to you. I'm Eric Lasan, and for today's presentation, Abby Fitts will discuss some of the recent COVID-19 legislation that affects employers and employees. Abby's a Willamette College of Law alum from the class of 2016. She's an employment law specialist and a guest speaker at the law school. Before law school, she served in the United States Navy for 10 years. And after graduating magna cum laude from Willamette Law, she worked for a business law firm in Salem and later opened her own practice. She now serves clients in the mid-Willamette Valley and throughout Oregon with her business and employment law needs. Abby recently talked to our business law students about the topic that she'll be presenting to us today. Thanks for joining us, Abby, and if you're ready, why don't you just jump right in?
Thanks for having me, Eric. It's a real privilege to be here today. So in March, it was actually late March of this year, President Trump signed into law the Families First Coronavirus Response Act. It actually went into effect on April 1st, so we've had about, almost 2 full months of working with and trying to understand this legislation as it affects employers and employees. The Families First Coronavirus Response Act will stay in effect through 2020. So as of right now, it expires on December 31st of 2020. My presentation tends to be fairly content-heavy, detail-specific. Even though I'm really just presenting the basics, there's so many exceptions and nuances that apply to specific industries or categories of employees. But like I said, I'm really only going to cover the basic information to sort of help provide the scaffolding so that I can help set the stage for really anybody trying to understand this legislation, whether that individual is an employer or an employee, so that anyone can understand sort of what their obligations are, what their responsibilities are, what their protections are, because this does affect both sides of the employment coin, right? So you have employers for whom this Families First Coronavirus Response Act, and I'm just going to shorten it now to FCRA, or else this presentation will be 2 days long. So on the employer side of FCRA, there's all sorts of obligations that employers prior to April 1st were not obligated to provide employees. And on the employee side of the coin, there's multiple protections and new benefits that apply to specific situations for employees that they need to know about. So this applies to both sides of the employment coin. Additionally, FCRA applies at the federal level, so this is helpful for employers and employees across the country. In addition, it also ties into state law, and across the country we have different kinds of leave laws that are offered to employees. So in Oregon, most Oregon employees and employers are familiar with the Oregon Sick Time Act, which obligates employers to provide protected leave every single year up to a certain amount for certain conditions. How FCRA plays into Oregon sick time is a state-specific question, but at the federal level, FCRA applies to really every state and every employer in the state, so long as they meet the employee threshold, the number of employees threshold. So specifically, when we talk about legislation and employment law, it's important to understand that oftentimes this kind of legislation really does boil down to obligation and benefit. So when you're listening to this, oftentimes it really matters whether you're listening to this as an employer or as an employee. Let's talk a little bit about what obligations/protections FCRA now places in every employment setting. FCRA has several parts to it that really cover different employee rights and protections based on certain situations. And specifically, there's really 2 specific benefits that come from FCRA for employees. One is paid family leave, and one is paid sick leave. And the carrot that the legislature gives to employers in order to ensure that they maintain these obligations is a tax credit. So we're going to kind of tease out specifically the paid family leave benefits and the details surrounding that benefit. We're going to tease out a little bit about paid sick leave and the basics around that. And then I'll briefly cover what the tax credit looks like. But I should preface all of this by saying that certain conditions have to be met in order to be covered by these leave laws. We can't just say, okay, well, the federal legislature, the Congress just passed FCRA, therefore I can take whatever leave I want whenever I want it. So as with any other legislation, certain conditions have to be met in order for an employee to qualify for paid family leave or paid sick leave. And then similarly, certain conditions have to be met in order for an employer to be exempt from providing these benefits. There are some carve-outs and exceptions for employers. So it's sort of very similar to other employment laws in that there has to be certain conditions met, and then sometimes employers get a carve out. So let's dig into paid family leave. All right, you'll see here one of the two main benefits that FCRA offers to employees, obligates employers to provide, is paid family leave. Not every employee will receive paid family leave for any reason. If any listeners are familiar with the Family Medical Leave Act, we shorten that to FEMLA. FEMLA is a national program. It's a legislative benefit given to all employees who work anywhere there are 50 or more employees. So any larger employer is obligated to provide unpaid family leave every year under FEMLA, so long as certain conditions are met. This paid family leave provision of FCRA, not to be confused with FEMLA, this paid family leave provision of FCRA sort of extends or adds on to FEMLA, but instead of kicking in at the 50 employee count, this is sort of unrelated to the employee count. We're going to get into employee count in a minute, but just because an employer is not covered by FEMLA normally does not mean that they are not going to be obligated to provide FCRA leave. So let me say that again. Just because an employer is not generally covered by the Federal Family Medical Leave Act, FEMLA, does not mean that they are not also going to be required to provide FCRA leave. Like I said, we will get into employee count soon, but employers who say, oh, this is an extension of FEMLA, I don't have to comply with it, would find themselves in some hot water. And here's some of the background for why paid family leave is now important. So we've sort of seen across the news, and probably many of us have experienced this in the wake of sort of as everything COVID-19 related started to make news, make waves, and schools and childcare facilities started to close, we found ourselves in an employment situation where a lot of employees did not have childcare ability. So their kids were going to be at home and their jobs were still expecting them, their employers were still expecting them to be at work. Probably on many anecdotal levels, personal levels, we know lots of situations where this was a reality. And so the federal legislature, so Congress came back and said, okay, well, this is what we're going to do. We're going to offer protected paid family leave for individual employees in this particular situation. The way that the federal government did this is by offering, requiring employers to provide 12 weeks of paid family leave for the purpose of school and childcare closures as a result of the public health emergency of COVID-19. So there's multiple caveats to this paid family leave at the very front end. So employers of 500 or fewer, so right there we see that Congress was identifying relatively small businesses on the national scope, right? So if you've got 501 employees, you are not covered by FCRA for this, for paid family leave. 500 or 499, and you are required to provide paid family leave. This is up to and including 12 weeks of paid family leave. And unlike the Federal Family Medical Leave Act, FEMLA, this is paid work, paid time, right? So FEMLA is usually unpaid. This particular benefit for the remainder of 2020 is paid. So the question is, who qualifies for this leave? If we know that there is a COVID-19 related closure of schools or childcare facilities, and the employee comes to the employer and says, well, my child's daycare facility is closed. I have nobody to take care of my child, and I need to take some time off. The employer has one final category that the employee has to meet before it is required to provide this paid family leave, and that is that the employee has to have been working for the employer for 30 days. So if new employees come to the employer, they might not necessarily qualify for FCRA's paid family leave benefit, but most do. And let's talk a little bit about what specifically, I identify here a qualifying reason. Let's talk a little bit more so we can identify the employee's been working for the employer for 30 days. We know that the closure of the daycare, the closure of the school is COVID-19 related. But what is the final qualifying reason? This is a situation where the employee cannot work or telework because the employee's child's school or daycare is closed. So this doesn't happen very often, but sometimes we have I have clients who will come to me and say, my employee needs time off, not necessarily because the school is closed, but he or she can telework from home. Do I still have to give paid family leave even though they can't come into the office? And the answer to that is no. If you have a position where you can work from home, then you would not qualify for paid family leave. This is a situation where you absolutely cannot wait tables or weld or do something that requires your physical presence at the workplace. And if you can meet that criteria and you can identify that the closure is related to COVID-19 and that employee has been working at your place of work for 30 days or more, then we know that that employee qualifies for paid family leave. So what does that employee get when he or she qualifies for paid family leave? Under FCRA, each employee will get 12 weeks of protected paid family leave time. Congress built into this legislation 2 initial weeks of unpaid time. But they reserve the right, essentially, for employers to work with employees to use already accrued paid time off, sick leave time, other types of leave to fill in paid time for those initial 2 weeks. After the first 2 weeks of 10 days, so a total of 5 working days and 5 more working days, Congress built in 10 weeks of paid leave. And what the paid leave looks like is 2/3 of the employee's regular rate of pay with a maximum of $200 a day or $10,000 in total for all of the 12 weeks of paid family leave. This just equals a total of 12 weeks. At the end of those 12 weeks, the employee has exhausted the protected leave time. And from the perspective of an employer, at that time, that's when the employee needs to come back. If the employee is not willing to come back, the protection of the federal leave law goes away. But if the employee does come back, what kinds of rights to reinstatement does that employee have? So if you are employing 25 or more and you've offered this and you've given, as you were obligated to do, this paid family leave to your employees, anyone with 25 or more has to reinstate that employee to the same or an equivalent position This is not uncommon for employers. They oftentimes, when we have employees leave, there's still a reinstatement right associated with that protected leave, and this is really no different. One distinction is just sort of the number of employees. The legislation draws a line between sort of how many employees are trigger the threshold for reinstatement rights. If you're employing 25 or fewer employees and an employee comes back from paid family leave under FCRA, the employer has to restore the employee unless that job has been eliminated for economic conditions or any other reason associated with COVID-19. So if this smaller business of 25 or fewer continues to struggle and has to thin down positions, and that employee on paid family leave is ready to come back after 12 weeks. If there's no position for that individual, contact a lawyer, but under the law, the reinstatement right is not there. There's also a significant protection against retaliation. So as with every leave law that I know of, there's a strong prohibition against retaliation for taking that leave. One of the reasons why reinstatement rights are so important is to ensure that employees who are taking protected leave given by Congress are reinstated to the position that they were at previously to taking the leave, and that there's no discrimination, no harassment, no retaliation for taking that leave. Well, let's talk about what kinds of employers have to comply with this law. So any employer who read the news headlines that there's a new law, who read blog articles, who read the actual law, every single employer I know was thinking, okay, another obligation, another benefit I have to provide, and especially when my business is going to struggle. If it's not already struggling, it's going to struggle. We all know that the economy is struggling. What now? What do I have to do? And do I qualify for an exemption? Or do I have to provide this? So really, I mean, on the face of it, this law is requiring businesses to provide leave, paid leave, for not getting work. And so the Congress thought about this, and we can see in the legislation that the primary target for this particular leave allowance was relatively small businesses on the national scale. So anyone employing 500 or fewer is what we call a covered employer. So that means that they are covered by the law. That doesn't mean it just means that they have to comply with the law. There are some exemptions that the legislation builds in. So specific exemptions would be healthcare providers and emergency responders. But even aside from those exemptions, Congress looked at small businesses of 50 or fewer. So now we're talking about, on a national scale, very small businesses. And the Department of Labor sort of effectuated this exemption by allowing businesses of 50 or fewer to identify allowing the leave, if allowing this leave would what they call jeopardize the viability of the business as a going concern. Businesses are allowed to claim an exemption. It's a slightly unusual exemption in that you don't request approval from the Department of Labor, but instead you have to go through essentially an analysis of this particular individual employee requesting this particular leave at this particular time. This analysis is an extremely nuanced employee-by-employee analysis. Even with 50 employees, that's quite a lot of analysis that an employer is going to have to go through to identify if this particular individual employee at this particular time qualifies for this family leave, or if it would jeopardize the viability of the business as a going concern. Some of the factors that employers may use under the law to determine whether or not they can afford to allow this employee to go at this time would be things like revenue determination, the financial health, or operational capability due to this employee's unique skills. What if allowing this employee to go at this particular time would create an insufficient workforce such that the business could not maintain operational capabilities. These are all things that an employer is allowed to consider when determining whether or not they can allow this individual employee to go at this particular time. So you see now that Congress offers and provides protected leave for individual employees in relatively small businesses on the national scale across the country, with reinstatement rights and this leave is essentially 12 weeks of pretty close to full pay for purposes of caring for children whose schools or childcare facilities have been closed as a result of COVID-19. Well, I said there were two parts to FCRA. The second part to FCRA with respect to obligations and benefits is paid sick leave. Well, across the country, we have, not every state, but anyone who employs here in Oregon knows that Oregon has a usually paid sick leave provision that was signed into law a few years ago called Oregon Sick Time. And specifically, as long as an employer is employing 10 or more, generally speaking, across the state, all accrued leave that an employee accrues or is front-loaded is paid time. And that is protected time so long as the individual is taking it for qualifying reasons. This paid sick leave is a little different. It's specific to COVID-19. And across the country, not every state has such a provision as Oregon, where employees automatically generate usually paid sick leave. So this legislation is nationwide, right? So every employee has this new benefit provided to them. There are no time requirements for this employee to qualify. So an employee who is hired on April 3rd can take paid sick leave so long as they meet the other criteria, regardless of how long the employee has been employed. So April 6th, if the employee needs to go on paid sick leave, the employer is obligated to provide that paid sick leave so long as the other criteria are met. So this particular legislation and part of FCRA is sort of intended to meet the situation where we've seen this happen a few times. I have with some of my clients where an employee is under a quarantine order or has to care for someone who's under a quarantine order, or maybe this individual has to care for someone self-quarantining, or maybe someone is symptomatic of COVID-19. So how does an employer handle these situations? We never had to deal with this. We didn't have to deal with it in February, but we started having to deal with it in March. And so FCRA speaks to the employer's obligations specific to those kinds of situations. Even though there is no time requirement for employees to meet in order to qualify for this paid sick leave, there are specific events. The legislation specifies these kinds of events as COVID qualifying events. And so long as an employee can meet one of these COVID qualifying events, they're going to be eligible for paid sick leave. These COVID qualifying events are: the employee has to be under a quarantine or an isolation order. The employee has to have had a medical provider advise the employee to self-quarantine for COVID-19 reasons. Can't be for other reasons, but has to be for a COVID-19 reason. The employee must be symptomatic of COVID-19, and not only symptomatic of COVID-19, but also be seeking medical diagnosis. So I have a dry cough and I have a fever is not sufficient for paid sick leave. It's I have a dry cough, I have a fever, and I'm getting a medical diagnosis. That is sufficient for paid sick leave as a COVID qualifying event. If the employee is caring for an individual who is under a quarantine order or who has been advised by a medical professional to self-isolate, this would qualify as a COVID qualifying event. Anyone who is caring for a child whose school or daycare facility closes, that's a COVID qualifying event. That sounds really familiar to the paid family leave if you're still with me. And then the legislation sort of provides this catch-all, any other reason deemed appropriate by the Secretary of Health and Human Services, alongside the Secretary of Treasury and the Secretary of Labor. Well, let's talk a little bit about this first one here. What is a quarantine or an isolation order? I'm not going to tease out all the definitions of what are COVID qualifying events, but one question we had, just as we're employment attorneys, as we're reading through FCRA, well, what qualifies as a quarantine isolation order? What about these shelter-in-place orders that governors have been issuing across the country? Do shelter-in-place orders, stay home, save live orders, do those qualify as quarantine or isolation orders? Especially with respect to allowing employees to fall on that COVID qualifying event or fall on that order as a COVID qualifying event. Yes, a federal, a state, or a local quarantine or isolation order for purposes of this quarantine isolation order COVID qualifying event category does qualify. Specifically, it's important to understand that there's a little bit of a nuance with respect to this particular COVID qualifying event. If the employer has insufficient work, so because of COVID-19, whether it's related to COVID-19 or not, if there's insufficiency of work that is in some way related to COVID-19 and that isolation order, this does not qualify as a quarantine isolation order for purposes of COVID qualifying event. It's a little bit tricky. So in order to qualify, the employee has to be subject to the order and unable to work or telework. So it's a little bit different than because of the isolation order, our workload is down and therefore you don't have enough work. That doesn't qualify as a COVID qualifying event for paid sick leave. But what does qualify as a COVID qualifying event for paid sick leave is to say, well, because of the quarantine isolation order, I cannot work or telework, and therefore I'm qualified for paid sick leave. Hope that's clear. If you have questions, please let me know. So specifically with respect to the details of paid sick leave, what does paid sick leave look like? We've talked a little bit about what paid family leave looks like. Let's talk a little bit about what paid sick leave looks like. Unlike paid family leave, the paid sick leave provision of FCRA distinguishes between full-time and part-time employees. So full-time employees get 80 hours of paid sick leave. And part-time employees get the amount equivalent to the average hours that they've worked over 2 weeks. It's not a huge, it doesn't need to be a big calculation, but employees who are working full-time are going to get are going to get their full 80 hours of paid sick leave. And then you just do the analysis for the part-time employees. Now, when we went, let's go back real quick to the reasons for paid sick leave. Under this reason, and under quarantine or isolation order, under self-quarantine advisement from a medical provider, or if an employee is symptomatic of COVID-19, then the employee will be paid a max of $511 a day or $5,100 total, specifically for their own illness. But where they are caring for individuals under quarantine orders or advisement from a medical provider, or if they are caring for someone for whom the child care facility has closed, these individual employees will get a maximum of $200 a day and $2,000 in total. So to really just sort of index up to what they're making as a regular rate of pay. So one question I've received from employers is at what point does already accrued benefits sort of run contemporaneously or play into FCRA? Employees, from the employee perspective, the question would be, can my employer apply this new paid sick leave to other benefits that I've been given? And there, so for example, when we talk about FEMLA, we talk about the Family Medical Leave Act. Oftentimes, qualifying reasons for FEMLA also run at the same time as qualifying reasons under Oregon Family Leave Act, for example. So maybe if for the same reason an employee is taking leave, the leave allowance starts to go down on both the state and the federal level. And so it's an important question to ask that employees and employers both ask is, okay, so now I have this new benefit or now I have this new obligation. At what point can I sort of check both the state allowances and these new federal allowances off at the same time? So the short answer to the question is no, employers cannot make employees take other leave at the same time. So for example, in Oregon, I mentioned before that we have Oregon sick time. Oregon sick time is a protected leave. An employer cannot make an employee take Oregon sick time leave at the same time as the paid sick leave or the paid family leave. However, you can agree. So for example, let's go back real quick to under the paid family leave here, where we talk about, see these 2 weeks that are unpaid. If an employee has accrued but not used 2 weeks or 40 hours of Oregon paid sick leave, that employee can elect to use, can elect to use those 2 weeks of Oregon sick time for the initial 2 weeks of paid time. Or the initial 2 weeks of unpaid time under FCRA, and can essentially draw on the 2 weeks of Oregon sick time paid time. So unless the employee agrees with the employer to use already accrued but unused time, then the employer is not allowed to force essentially an employee to draw on already accrued time. I should also mention with respect to the tax credits, and we're going to get into really quickly, we're going to get into tax credits. I'm not a tax lawyer. I should also mention, though, that employers will not be eligible for tax credits for any extra or non-FCRA paid sick leave, right? So allowing an employee to draw on and draw down on their already accrued and unused Oregon sick time, for example, does not qualify them for additional tax credits under FCRA. All right, so let's talk a little bit about so what employers qualify for or are covered by paid sick leave. When we talked about paid family leave, the question was, at what point can an employer of 50 or fewer receive an exemption, essentially, for having to provide this leave? And the same analysis applies under paid sick leave, except every employee is eligible for, and no employer is exempt from providing the personal paid sick leave reasons. So back here, this quarantine or isolation order, self-quarantine advisement, symptomatic of COVID-19, none of those are allowed to be exemptions for any employer, regardless of size. However, employers may seek an exemption for purposes when an employee is taking paid sick leave for the other two purposes. So for purposes of school or childcare facility unavailability. I misspoke. It wasn't the last two. It was just the last COVID qualifying reason. So back here, if an employer is confronted with an employee who wants to take paid sick leave for a COVID qualifying event, so for example, caring for a child whose school or daycare facility closes, and that employer employs 50 or fewer, and the employer goes through the analysis specific to that individual employee and determines that there is a justifiable reason for the business to disqualify or to say, no, you may not take paid sick leave, then that employer is likely able to seek an exemption, or is likely exempt. I shouldn't say seek an exemption. It's pretty standard that employers seek exemptions, but in this particular case, employers are instructed by the Department of Labor not to send any applications or requests for exemption to the department. Essentially, what the employer has to do is provide a defensible position as to why they rejected or didn't provide covered leave, and let the chips fall where they may until such time as they're called on the carpet. And as long as they have a justification for that under the law, it looks like they're going to be okay. Before we finish up, I just wanted to address a quick piece as far as this legislation is concerned. I said, that FCRA is divided into two sort of benefits/obligations, but there's a carrot at the sort of woven throughout this legislation that addresses the employers. And so, as an employer is reading this legislation, they think, well, how am I going to pay for this? All of a sudden now, within days of President Trump signing this legislation, now all of a sudden we are required to pay 12, maybe 14 weeks of paid leave within all the way through till December. This is a new protection, a new legislation that I had no way to budget for, no way to prepare for. That's sort of where employers are coming from. The Congress built into this legislation sort of essentially a payback for allowing employees to go on leave. And that is that employers will be eligible for reimbursement of the cost of the leave through refundable tax credits. And we've talked a little bit about how those tax credits won't apply if employers are offering more than what FCRA allows. But to the extent that employers are complying with their obligations under FCRA, they can request those refundable tax credits. And then finally, just from a litigation perspective, what happens if employers violate this law? It's hard to imagine at this point. Well, it's not hard to imagine. It's hard to. I guess it is hard to imagine that there won't be litigation associated with FCRA. And specifically, the legislature built into this legislation that FCRA violations are essentially considered violations of the Fair Labor Standards Act. And under the Fair Labor Standards Act, the Department of Labor can bring an enforcement action, or the employee can bring a private action. If the Department of Labor brings an enforcement action on behalf of an employee, the employee is entitled to recover the full amount under paid sick leave, which is the greater of an employee's regular rate of pay or the applicable minimum wage, which is either federal, state, or local, for each hour of uncompensated paid sick leave taken. So, however, if an employee chooses to bring a private right of action, we're talking about damages associated with the litigation, which could exceed well above what the Department of Labor's enforcement could be. So it's in employers' best interest to ensure that they understand the law, that they comply with the law. If they don't understand it, that they seek legal advice for interpreting the law specific to their unique situations. And it's important for employees also to understand what their rights are, what their protections are, and how far those protections go, so that they're not caught unawares. If you have any questions, I can be reached at this email address or this website.
Awesome. Abby, that's an awful lot of information that you just provided in a very short period of time. So thanks so much. It's great that it's in this format that's being recorded so people can go back and review information. And then I think it's really fantastic and much appreciated that you've provided both your website and your email address for folks to reach out to you for with follow-up questions. I have a couple questions that I've collected along the course of your presentation, although many of the questions that came to mind you also answered along the way. So thanks for all that thoroughness. But this is kind of a a 30,000 foot view question. But as you're seeing all this unfold and play out, do you feel that the system is working so far, given how quickly all this has had to to the changing circumstances and how quickly all this needed to unfold?
That's a good question, Eric. I think as we get further up past where we're at now, I think we'll be able to see a little bit better. But my initial experience with this law, the benefits that it provides, and the obligations that it sort of lays out for employers, it seems like it is working. As with really any legislation, we will see I think we'll see some litigation associated with what is alleged to be a violation of rights on the employee's part. But to the extent that the intention of the legislation is to stopgap, sort of stop the hemorrhaging, I think it's doing its job. I have had many conversations with clients who understand the intent behind it. And unlike really any other time that I've seen in relationships between employers and employees, employers are willing to bend over backwards for, to help their employees through this time. And I think also employees are very grateful for the generosity of the employers at a time like this. They're grateful for their jobs. They're grateful for the protection. And I think the legislation is specific enough that it is addressing the unique needs associated with this time. And it's not really adding on additional obligations beyond COVID-19 obligations to employers. So from both sides of the coin, to the extent that the federal legislation can really meet any specific and nuanced needs, I think it's doing the best job it can.
Okay, right on. Well, that's good to hear, especially since you're right there seeing everything. And speaking of both sides of the coin, do you have, do you focus in one area or the other in terms of employee or employer, or you find yourself working with both sides of that coin?
It's interesting whenever I speak with Willamette students, I always start with this idea that, you have in employment law more like almost more than any other area of law that I'm familiar with, you have pretty clear lines of demarcation. And that's not to say that attorneys won't work both sides, but the sort of the practice of employer employment law is really different than the practice of employee employment law. And by that I mean employee plaintiff heavy law is really litigation driven, and a plaintiff's attorney is really good at identifying violations of rights. An employer attorney is really good at advising on best practices, risk avoidance, and we draft a lot of handbooks. I'm an employer attorney. I do a lot of business law, a lot of advising businesses and employers, and I really, really enjoy referring out any employees that come my way because I have a lot of respect for all of the employee attorneys in the area. So.
All right, cool. Thank you for that. Speaking of, you just mentioned Willamette Law students and the law school in general. How do you feel that this is kind of personal to you, I hope you don't mind me asking, how do you feel that the law school prepared you for the practice that you're doing now?
Oh, I'm probably like a lot of law students, even though I'd had a couple other careers before coming to law school and I had a large family. I thought I knew sort of what I wanted to do. And it turns out that I didn't quite know what I wanted to do when I came to law school. And I benefited tremendously from really every single professor that I had teaching me along the way. I think one of Willamette Law's biggest strengths is the way that our professors are absolutely so talented and gifted at applying the sort of the headiness of law to the actual on-the-ground practice of law. And really for me, the turnaround was when I last minute had an opportunity to join the Willamette Law Legal Clinic and joined in the business law clinic. The very practice area that I sort of shunned and thought I'd never practice became my bread and butter. And for that, I'm enormously thankful. I received sort of a very comprehensive and a well-rounded a legal education, both, all from the heady, constitutional law and the subject matter that we digest in those classes, to practical experience in trial practice classes, and then in meeting clients and on the ground, sort of the nuts and bolts of running a practice I got from the legal clinic. And then even throughout my practice now, I draw on and lean on and seek the advice of many professors that I met back in 2013. So I really am grateful for the education I received.
Awesome. Well, I'm really glad to hear that. I'm a huge fan of experiential learning opportunities.
Yeah.
So I think it's so cool that our law school weaves such practical application opportunities into the curriculum. Well, I have one more question, and it's a little bit kind of looking forward.
Okay.
As states and local governments move to reopen. What's your sense of how this aspect of the paid leave will play out as more people are going back to whatever a normal work situation is going to be? Do you think there'll be more folks needing to take the family leave?
That's a great question. A lot of this would require me to know a little bit more about the trajectory of the virus and how it will impact our daily lives. So I don't know the answer to that question. I will tell you, though, from an employer's perspective, just sort of risk aversion for my clients. I think I'm mindful of the fact that the more businesses that open, as great as that is for the economy and for their books, the more concerned I get about exposure. So employers have to be mindful of, so for example, if they're a salon or they're a fitness facility, they have to be mindful of both the health and safety needs of their clients, but also the health and safety needs of their employees. I've got clients who have employees who refuse to wear masks. Well, how does that work with members who might be coming in? At what point, and how do we navigate this new normal, considering the governor's orders, considering employee demands, considering employer obligations? What role do releases of liability and waivers play into this new normal of ours? I think the more we expand and open, the greater the risks are for my clients. And so I consider that a very important part of this, of the next few months. How FCRA plays into that, I don't know. The further down the virus goes, the less important it becomes with respect to reasons for leave. But of course, and I guess now that we've got summer coming up, the same sort of summer vacation issues that arise with all employees this time of year will be pretty much similar, I expect, with my clients this year. But I don't know if we have a resurgence in the fall, then we're going to probably lean heavy on this legislation again. Mm-hmm. And if it continues through the summer, then we might not ever walk away from it. But certainly it will be in effect through the end of the year. And to the extent that provides stability, protection, and something to some sort of predictability for both the employer and the employee, I think that's a benefit. Excellent.
Well, I know I just asked you to look into a crystal ball. So thanks for kind of entertaining a few different scenarios that might lead to some different situations. Well, unless you have any closing thoughts, this might be a good time to wrap up.
Well, I just wanted to say thanks for the chance to talk about this. I told you before in our phone conversation, but I really do embrace any opportunity to talk about this. So if anyone has questions, please feel free to email or contact me on my website. I'm a nerd like that, and I really like to talk about this stuff. It keeps me sharp too.
Oh, well, that's excellent, and we deeply appreciate your time and sharing this with us today. This excellent and engaging presentation was I think very helpful, probably for a lot of people who will be viewing this, and hopefully our audience enjoyed and learned from this expertise as much as I did.
I hope so.
speaking of our viewers, we really appreciate you joining us. And if you enjoyed this presentation, stay tuned as we'll be adding new content weekly. Please share your feedback with us and feel free to send suggestions our way for additional content to alumni@willamette.edu. And thanks again, Abby, for this time today. It's been fantastic. And take care, everyone.